Welcome to the Probate Podcast, where we talk about all the things you didn't know you need to know about probate. My name is Sherri Lund, and I'm so glad that you're here. I want you to understand the process and to know what to expect because it's going to make things easier and it's going to save you money. And I'm here to show you how. Hi there, my name is Sherri Lund, and this is the Probate Podcast, and I'm so excited to have you here today. I'm here to help people work through the overwhelm that comes along with probate. And my guest today is Teresa DeFord. She's a local attorney here in the greater Houston area, and she works with family law and other things we'll be talking about in a little bit. But she is an expert on this topic. You're going to want to pull out pen and paper because she's going to tell us how we can avoid probate. That's a question I get asked a lot. And so I think it's really great that an attorney is coming on to tell us what we can do to avoid going into her office, maybe not. So we'll see. Teresa, thank you so much for joining me today. I'm so glad you're here.
Thank you so much for having me. I really appreciate you asking me to join you.
So let me tell you a little bit about Teresa. Teresa comes from Michigan, and she and her husband attended Michigan State University. She minored in criminal justice, and that took her into a career as an intelligence research specialist with the Drug Enforcement Administration. That career took her to Washington, D.C. and San Francisco and eventually Houston. She went to all parts of the country on the edges of the country. And then in 1992, she started law school at the University of Houston Law Center. She finished that in 1995, and her career began in law with civil litigation. She specialized in oil and gas work. In 2012, she opened up the DeFord Law Firm, and that's where she supports her community with the services that she's equipped herself with. Just this month, they were voted the best real estate planning and probate attorney by the readers of the Living magazine in the Woodlands. Teresa is a graduate of the Leadership Montgomery County class of 2009 and former member of the Executive Women's Alliance and the director of both the Montgomery County and the Woodlands Bar Associations. Teresa is an active supporter of the Leukemia and Lymphoma Society. That organization holds a special place in her heart. We'll let her talk about that. And outside of the firm, Teresa enjoys her family life and living in the Woodlands with her two spoiled dogs. She takes them everywhere. Teresa, again, thank you so much for joining me. I'm glad to dive into this topic with you.
Thank you. Thank you for that nice introduction.
Tell me about you as a person. What do you like to do? How did you get into this part of the law?
So many things I love to do. I'm a huge reader. I read all the time. I love music. We have such a great opportunity to see live music here in the Woodlands, the Cynthia Woods Musical Pavilion, and there's music going on all the time, free and paid stuff. And so we love to do that. We take the dogs a lot to all of that. My husband won't let us go anywhere without the dogs if he can help it. It's been a little too hot for that lately, but yeah, this area is so wonderful. There's so many fun things to do. You mentioned the Leukemia and Lymphoma Society, and I got involved in the Leukemia and Lymphoma Society probably been 15 years or so ago. I started running with their team and training program where you can work to get fit, all people of all abilities. You don't have to be a big runner or anything. They also do triathlons and swimming. I never did any of that. But I ran like 10 half marathons with them to raise money for the cause and have also participated in other fundraisers. My mom is a non-Hodgkin's lymphoma survivor of 20 years. And she had several of her family members pass away of blood cancers, including leukemia and multiple myeloma. So it's a cause that's near and dear to our hearts to make sure that we continue to raise money and do research for that work.
And then how did you go from the oil and gas industry into family law?
A lot of people ask me that. Over the years, I think it became clear to me that there was a big difference between representing corporate legal departments, which if you're representing companies in commercial litigation, that's who you're dealing with. Not that there aren't very nice people in those departments and very nice people in the insurance companies that you may deal with, but I felt like I could make a bigger difference in dealing directly one-on-one with the actual clients, right? Individual people. Several years ago, we had a situation where a very close friend of ours lost her husband completely unexpectedly. Our oldest boys were quite young at the time, and she just had no idea where to go, what to do, who to turn to. And it opened my eyes about how much lack of knowledge there is out there to try to prevent you can't always prevent all of the heartache that goes along with losing a loved one, but there's a lot of things that you can do to help make that process easier. And that became important to me to help people with that. I started doing estate planning and some of the probate. I also started doing family law because they all kind of work together. And again, there was just such lack of knowledge out there and a lot of fear. I think that's the thing that concerns me the most, is that when there's lack of knowledge, there's fear. And when you're going through difficult times, the fear can be so overwhelming. And I really wanted to try to help people get past that fear so that they can really move on with their lives.
Yeah. I can really relate to that. That's one of the reasons why I'm in this space as well. I saw the gap between what is out there. Knowledge, lack of knowledge is a big part of it. And there's not a lot of books on probate. There's workshops and things on estate planning, and there's things to do once you get into probate. But if we can minimize the risks and get people talking about conversations that make them less fearful, knowledge is power. If they shine the light on what's there, then they can see what they don't know. And that's what brought me here. It's a big passion of mine.
Yeah, I totally agree that knowledge is power. And you're right. There's a lot out there about estate planning, about what to do, but not a lot of knowledge about the practical aspects of what happens if you haven't done the estate planning or if you haven't taken other steps to those issues.
And I know one misconception a lot of people have is that that's what attorneys are for. Like, if there's a problem, all of the problems are going to be solved by you guys. And that's just not the case.
Sometimes we can't fix everything once it's done right to begin with.
Right. But I mean, if somebody needs a locksmith, that's not necessarily in your wheelhouse that you need to do.
True.
And especially now with families being so mobile and not always just down the street from mom and dad. They're needing things that they didn't necessarily need before. So what are some misconceptions that people have about probate or about attorneys? What do you think? What comes to mind when you think about lack of knowledge?
There's a lot of misconceptions about attorneys. I think that a lot of people think that we're scary, that we're out to take all their money. And not to say that there aren't bad people in every profession, right? But I truly believe that most attorneys are wanting to help people. We got into this profession because we're helpers. We're here to help. And I think most people have fears about attorneys and dealing with attorneys. Some of the other misconceptions I think about estate planning and probate is that there's a fine line between things that I can do myself and things that I need an attorney for. One of my always big concerns is that there are things that people can do themselves. And we'll talk about some of those things here. But it's still always good to at least talk with a lawyer and say, here's my situation. What do you recommend? And a lot of us do at least initial consults on this kind of stuff for free. So you can get a lot of information, a lot of ideas, maybe without necessarily having to spend a lot of money. If you don't handle some of this stuff up front, you will spend a lot of money in the back out, or somebody will. Your heirs, your survivors will spend a lot of money and a lot of heartache on the back end to fix everything. Another just big misconception is, well, I don't have that much. It's not going to be that big a deal, or they can handle it. There's just so many little things. It's not knowing what you don't know.
Yeah, I found that to be true too. And as I was preparing for this call today, I was thinking, I don't know of like a book or a movie that's made about probate.
No, because it's kind of a boring court process, really.
Right.
If you wanted to get into the craziness of some probate matters, the Anna Nicole Smith case was a big one, probably was that 20 years ago now, where she was fighting with her husband's son over that estate. So more recently, the case of Aretha Franklin, there were competing family members saying there was an actual written will, and then there were some handwritten notes that had been left in the couch cushions. And interestingly, I don't know all of the details of that, but they found that those handwritten notes were Aretha Franklin's intent of what she wanted to be done with her estate, and the court held that as a will. So those are kind of some more public things about probate, but the actual process of it in the court system is kind of boring.
Yeah. And I'm thinking about Suits episodes and things like that. So those Suits episodes might contribute to the fact that attorneys are out to get us and to make all this money, and they're really not. But the probate and estate planning people that I have met, attorneys that I have met, are for the most part lovely people.
I just started watching Suits. I'd never seen it before. And a lot of lawyer friends actually recommended it to me. Like most lawyers, We generally don't like lawyer shows because they're not realistic in the slightest, but it's still a fun show.
So let's talk about things that people can do to avoid probate. I hear this question all the time. Do I really need to go through probate? If I have this, if I have that, do I really need to go through probate? So I'm so excited that we're going to talk about that. And so what's the first thing that you would say the average person could do to avoid probate? And why would we want to avoid? Maybe we should start with that.
That's a great question. The probate process in Texas is not an extremely difficult one. It's not incredibly expensive or time-consuming overall. In some other states, it is. And there are a lot of reasons to avoid probate in other states. I don't necessarily feel like it's necessary to avoid probate in Texas, but if you can, if your estate is set up in such a way that you can, certainly no reason not to take advantage of that and not have to have your family go through that probate process once you're passing. And a lot of that depends on how complicated your estate is, whether you've got property in many different places, different states. Uh-huh. And so that can inform whether it's going to be necessary to go through probate or not. So it's not something necessarily to be afraid of. However, like I said, why not avoid it if you can, if it works for you? So one of the biggest things that people can do to avoid probate is to make sure that any account on which they can designate a beneficiary, that they do that. One of the prime examples of this is life insurance. So a life insurance policy is a contract between you and the life insurance company. You designate a beneficiary, and upon your death, the life insurance company pays that policy amounts out to the person that you designated. That is always outside of probate if you have designated a beneficiary. Usually the life insurance companies are pretty good about making you designate at least the primary beneficiary, but you want to make sure you have backups, because if that person dies before you do, then there's no beneficiary when you die. Backup beneficiaries is really important to that. Other examples, though, are retirement plans, 401ks, IRAs, a lot of stock accounts now you can designate beneficiaries. Anything that you can designate a beneficiary to, that automatically passes outside of probate, and it goes directly to the person that you've named.
And you don't have to talk to an attorney about those things, correct? You would just talk to the companies that hold those accounts.
Right. Usually you fill out a form. These days, a lot of them are online, and you fill it out. You want to review them fairly regularly every few years to make sure that they still have the information right and to update things if things have changed. One of the things that you want to be careful of, though, is naming minor children as beneficiaries of life insurance. That's a bad idea because they can't get the money until they turn 18 if you do that. So in that situation, you may want to talk to a lawyer about how best to structure that or how best to name the beneficiaries so that the minor children can still take advantage of those life insurance proceeds through somebody else managing it.
And then obviously, if the children are not minor anymore, you can change that if you want to. What's another avenue of avoiding probate that you could?
For your bank accounts, as long as they are joint bank accounts, say that you have a bank account with your spouse and you are named jointly on those, whoever dies first, the account is still automatically in the surviving spouse's name. So making your accounts joint is an option to do that. And then also naming a payable on death person. It's kind of like that beneficiary designation, but a little different. Usually this is only with bank accounts, and you can go to the bank and say, look, when both of us are gone, I want this paid out to this person or persons in whatever shares you want, and they will pay it out just like a life insurance policy. Again, avoids probate. Nobody has to go and get authority from a court to go access that bank account.
So I know of a scenario where a woman had her adult daughter sign on her account, to be able to pay her bills and to be able to pick up medication and that sort of thing. Is that a good idea? Is that kind of what you're talking about here, or is this something different?
It's something different, not necessarily a bad thing to allow someone to be a signer on your account, but that really only gives them authority while you're still alive, right? There's other ways to give somebody authority to sign on your behalf, and that's through a legal financial power of attorney, also called a statutory durable power of attorney, that can give someone else legal rights to access your bank accounts, write checks on it if you give them authority to do. But again, that only works while you're still alive. If someone is not an owner of the account, then they don't have any rights to it once you're gone, unless you have made it payable on death or it goes through the probate process.
So then that account would be frozen?
Correct.
Okay. So what if the person on that account takes advantage of the money that's in that account? And there's other beneficiaries that have a right to those assets. But it's a catch-22, isn't it? Because
it is a catch-22. And that's the risk. That's definitely a risk when you give someone authority on your account. There's a risk that other beneficiaries, when you're gone, aren't going to get what's left because it may not be there. That's always a risk. When you name somebody as a power of attorney or put them on your account, you just have to really make sure that you are designating people you trust. There are options for the other heirs to come back and sue the person who took advantage to try to recover those funds. But obviously, that's not ideal.
Yeah. Aren't there some things with real estate too that you can do? Transfer on deed, transfer on death?
Yes. And so that's my next idea. To avoid probate, for most people, their biggest asset is their house, especially as we're older and we're at the end of our life. We've consolidated our accounts. We may have a house. We may have one or two bank accounts. We've got life insurance or a 401k. And those pass automatically if you've got beneficiary designations. So for a lot of people, the only reason they have to probate is because of the house. A lot of people don't know that if you own a house with anyone, your spouse or anyone else, just because they die doesn't mean you automatically have 100% ownership of it. Technically, you do. Technically, if you owned it and you have a will that says your spouse gets everything, then, technically you have that, but there's still a process you have to go through. That's what probate does in absence of anything else. Probate will allow you to transfer that house into the survivor's sole name. But again, it's a process. Sometimes if it's not the surviving spouse, but say surviving children or other heirs, and they don't have the money to pay the mortgage while the probate process is taking place, they can risk losing the house or have a lot of problems trying to come up with the money to keep it paid up. So having a transfer on death deed to the next generation can allow them to sell it immediately. And the process for this is very simple. It is a deed. It's called a transfer on death deed. You can leave to your surviving spouse and then, beyond that to other family members. And it is filed in the property records. It's not effective until you die. It's just there to put people on notice. You can revoke it at any time. If you get mad at those kids and don't want them to inherit it anymore, you can take it away. Okay. As long as you haven't passed. And then once you pass, then there's just a notice that's filed in the court and the property records that indicate that you've passed away and now title vests in your surviving spouse or your other heirs as you've directed. It's automatic. So it's a great tool, especially in situations where, like I said, the biggest or sometimes sole asset of your estate is that house. Totally avoids probate to do that.
And so is there a place on there where you can have your primary beneficiary or that you would transfer it to, and then you can have the backups on that as well?
Alternates, right.
Okay.
So a lot of times we do that where, again, it's the surviving spouse is the primary beneficiary. And then say you've got two kids, and then if both spouses are gone, it goes to each child in equal shares.
So then also there's cars, there's RVs, boats, anything with a title?
Anything with a title. There are forms through the Texas Department of Motor Vehicles that allow you to designate a beneficiary to your vehicles. VTR 121 is the form. You can look it up on the Texas Department of Motor Vehicles site, and you can designate who you want to get your car when you pass. So if you own a car in your sole name and you want your wife to get it, you just name your wife. They take that to the DMV and they transfer title. There's also an option if you haven't filled out those forms before passing that your heirs can use. There's another form. It's an affidavit of heirship form that is pretty simple to use. As long as it's pretty clear who is entitled to get the car, then they'll accept that.
All right. And then using a trust.
Yeah. So trusts are kind of the big thing that you'll hear a lot from people. Avoid probate, get a trust. And absolutely having a trust will avoid probate if done correctly. It is something that you will need a lawyer to do. You should not prepare a trust on your own. LegalZoom, I know, prepares wills. I don't know if they prepare a trust, but I would not trust LegalZoom to prepare a trust in your name. There's just a lot of steps that go through it to create a trust and fund it. So a trust is sort of a fictive entity, like a company. You actually create this entity and then you put all of your assets in it. You can put your house in it. You can title your bank accounts in it. You can title your cars in it. Anything that you own can be put in the trust.
So you have to take extra steps to take those things and put them in there.
Yes.
So I think one misconception people have about trust is, well, I have a trust, Somebody said I need to have a trust in, so I'm good. And there are steps to go through all that.
Right. That's the funding process. Exactly. And we see this a lot where people go to some seminar that says, oh, we're going to do living trusts or revocable trusts for you. And then they never speak to these people again. And nothing gets transferred to the trust. So they've got a pretty document that has their name on it, says all these wonderful things about what they want to happen, but there's nothing in it to do anything with.
Does the individual or does the couple go through steps to fund them? Or is that something that attorneys do?
Usually the attorney's offices will help you with this, but some people want to do it themselves and they can. It's just an attorney should at least advise you of what needs to be done. And if the individual chooses not to use the attorney, they can do that. But what we also see though is, you can create the trust and you can properly fund it. But say you sell your house and then you go buy another house, you have to remember to title that in the name of the trust, the new house. Same thing with cars if you transfer things. Trusts are great tools, but you have to know what you're doing. I had a situation recently where a gentleman came to me and his mother had a great trust. She had put everything in the trust, thought that she was avoiding probate on everything, but she had one bank account that had about $8,000 in it. And that was in her sole name, no payable on death. And it wasn't titled in the name of the trust. And we had to probate for that one account. So it happens fairly regularly that people just leave things out. And so probate is still necessary. So if you're going to do a trust, make sure you keep up with it. Make sure that you've done the necessary steps to make sure all of your assets are in that trust so that it's workable.
Right. I talked to somebody the other day and they were asking me, of course, I don't practice law, but they were asking me if I thought that they should talk their mom into getting a trust. And mom has one house, one car, one bank account. And I said, I don't see the reason for that, but I always need to check with an attorney.
Right.
So I said, why would you think you need to have a trust for that? And she said, somebody said I needed to do that. That's the safest way to avoid probate. So it's really nice to know that all three of those things, she could just name a beneficiary, and it's so much easier than going through the process and remembering to set up a trust correctly.
Yes, that's exactly right. In all three of those situations, all of those could be handled through non-probate means, and they wouldn't have to have a trust.
Everything was already consolidated into one account. And I think her mom is 85. So she's probably not going to be buying a lot of more cars or houses or anything. And the other thing I want to say is that other states are different from Texas. You mentioned that a while ago.
Yes. Yeah. Every state's different.
Yeah. One of the things I noticed when I was early on trying to learn more about probate was that all the information does not pertain to Texas. It's different from state to state. And it's different from county to county in some cases in how they're going to work things out.
Yes. I mean, there's rules that apply to the entire state of Texas, but each court often has their own processes. And so that can have more requirements through the probate process. It can determine how long the probate process takes based on those different requirements.
And so someone else might advise us to have a trust, for instance, because that would be a lifesaver in California, say, or New York, maybe, where they really need to have those things in place. Some of the advice that comes in can come from other states and other places that may not be pertinent to what we do in Texas.
Right. If a trust is created in another state properly and properly funded, we get a lot of people obviously moving from California here and they have trusts. A lot of them have trusts because it's a good idea.
It's a thing to do.
And often those trusts are perfectly fine to use in Texas. I mean, you can create a trust anywhere and it's still going to be effective as long as it was properly done and properly funded. It doesn't matter where you live when you die. We have people moving here all the time. And as long as they have an attorney in California that can verify that that trust was created properly and funded properly, it's just as good here as it was there.
Really good to know. So what else do you think about avoiding probate? What else do we need to know?
The one thing that I still recommend people having is a will. They really still need to have a will. It's a catch-all, if nothing else. Even if you think you've done everything to the T and that you have crossed all the T's and dotted all the I's, having that will to allow anything that was left out to be probated is key. Because again, as we discussed, there's so many times when people just forget. They buy something new and they haven't done these proper procedures. A lot of times there's just that one thing, right, that needs to be handled. And if you don't have a will that doesn't say who you want things to go to, then it's a whole big mess. Now we are talking about having to go to court and not only asking for the court to probate your loved one's estate, but they also have to do something called a determination of heirship. That means they have to figure out who gets it. And it's not straightforward. It's not, well, you were married and your spouse gets everything, or you've got 2 kids and their 2 kids get everything. There has to be proof of the marriages, of the children, that there aren't any unknown heirs out there that we don't know about. And so that's a whole big process. It can get expensive to go through that. Sometimes we find heirs that perhaps the person who died didn't want anybody else to know was around. Right. So that can stir up a whole can of worms. But, it's just so easily dealt with by a will, as having that. Hopefully, if you've done some of these other actions, you don't need to probate the will. But if you have it, it's better than not having it and having to deal with the problems that occur otherwise.
Right. And that's the thing that people want to avoid, is all of that stuff. And so by planning a little bit ahead and mitigating these things that we know about, it's still going to be stressful. Probate is stressful. Life still goes on. Probate doesn't stop. Life doesn't stop just because probate began, but we can do so much to help those that come behind us and not dump a bunch of problems in their lap to try to sort out. What's a common question that people ask you about probate law?
Well, first they ask, do they need a will? That's always the big one. And I tell everybody, yes. Even young people should have wills. It's not a difficult process. It's not a very expensive process. It's just better to have them. If you're young and married and have children, even if you don't have a lot of stuff yet, you need to have designated guardians for your kids. You don't have to designate guardians in a will, but you certainly can. There are some situations, certainly, where you may have a will and all of the things have been taken care of and you don't need to probate, right? Or secondly, it may be that it's not worth probating. If you've got a bank account with $500 in it and it's going to cost you $3,000 to $5,000 to probate, it makes no sense. Those are all questions that we sit down with people and really evaluate whether it makes financial and emotional sense to go through the process.
Can you talk a little bit about small estates, muniment of title?
Sure. So those are what we call summary probate processes. They still are part of the probate. A muniment is actually, it is still a probate process. You still file with the county court in which the person died or where the property is located. And it's generally just an order from the court saying who the heirs are and that title can be transferred. It doesn't open up an administration. It may be necessary if there are debts. And the only way you can do it is with a will. You can't do it if there is no will. But if there's a will, it's very clear who is entitled to the assets and there's not a need to deal with debts, then that can be used in that circumstance. You also cannot use a muniment if Medicaid has provided benefits to the person that died in a certain period of time. A small estates affidavit, and I don't do these very often, and there's a lot of lawyers that are of the opinion that rather than do a small estates affidavit or a muniment, that you should do a full probate, because the risk is if you don't do that and a debt pops up later or some other issue pops up later, that you might put yourself at a disadvantage. But a small estates affidavit is essentially used in circumstances where there is not very much in the estate and you have to have witnesses to determine who the heirs are and then file that with the court. It's still a court filing. In a lot of these cases, the filing fees are the same. So it's really important to talk to a lawyer about your situation to figure out if those are options that might work.
What do you think we should be asking about probate or avoiding probate?
Well, I think for anybody, sitting down with a lawyer and providing the lawyer with a good overview of their estate, where all of their accounts are, how they're all set up, involving a financial advisor if you have one, so that you are looking at the big picture to determine how everything is set up and then getting advice on how best to manage those things. It's about planning.
Yeah. And so if I wanted to do the transfer on deed, is that something I would research and come to your office and say, this is what I want to have done, or transfer on death? Did I say transfer on deed? I think I probably did.
Transfer on death. So we do these routinely with our estate plans, but we do them separately as well. If somebody says, I've already got my will, but I want to do this. They come to us, we pull a copy of their original deed from the property record. So we get the legal description, we create the deed, have you sign it, execute it. We record it with the property records. That's a key thing, that it also has to be recorded in the property records. And so,
because that's a fairly new thing.
It is. I think it's been around 4 or 5 years, something like that.
Right. Not very long. Yeah. So if you've been in your house longer than that, chances are you don't have that transfer on death. So they can come to your office and you can help them with that.
Yes. Mm-hmm.
Yeah. All right. So speaking of your office, let's talk about some of the things you do. What is your typical client, and what are some things you do to help empower them with knowledge and information?
Well, typical client, that's a good question. I mean, we appeal to people who are looking for knowledge, that are trying to gain knowledge, who are trying to figure out their issues. And so whether that's on the family law side, on divorce or custody matters, adoptions, or whether that's on the estate planning probate side, I think people come to us wanting to know more and knowing that they'll get information from us to help them know more.
I wanted to promote your workshop.
Oh, yes.
Yeah, that's one of the things that you do to help.
So for I think 6 years now, I've been working with a certified divorce financial analyst, Denise French, with Divorce Strategies Group. And we have been co-hosting a women's divorce seminar called the Wise Women's Guide to Divorce. We do it, I don't want to say monthly because we take time off during the summer and during the holidays because people are distracted and don't show up for those at that time. But we host them probably 8 or 9 times a year. And during those seminars, we just educate people. It's completely no obligation. I talk for like an hour and a half on family law. Denise talks on the financial side, how to prepare yourself, how to plan and know when you need help. We usually have a real estate person and or a mortgage person that talks about the special issues of real estate in divorce. And then we have a counselor or a life coach to help people kind of walk through those emotional situations. Obviously, divorce is very emotional and people need a light at the end of the tunnel to know that they're going to be okay. They need the tools to deal with that. So we really enjoy providing all of those resources to people so that they can have some hope. And again, like you say, knowledge is power. So we do that. And then we just started doing some estate planning seminars as well, where we're educating people on the importance of estate planning, what they need to know. We talk about probate and why you want to do estate planning and the importance of that and why how to make things easier on the other end.
Yeah. I think that's great. Do you have another class that's coming up? Just check your website, or how should we find out about this class?
My website, which is DeFordLawFirm.com. We also have a Facebook page and they should be on there. I think we have 2 more Wise Women's Guide to Divorce workshops this year, September. I think it's September 21st. And I've forgotten the October date. I want to say the 16th. And then we're going to have 2 more estate planning workshops in September and November this year.
Okay. All right. Good deal. Well, that's it for Avoiding Probate and this conversation with Teresa. Teresa, we have a lot more to talk about, so maybe we can have you come back again in the future to talk about another topic around estate planning.
I would love to. It's been fun.
I'd love to have you back. Thank you so much for your time. Thank you, listener, for your time and for coming to the Probate Podcast. I'm so glad you're here. Teresa and I both want you to be empowered, to know that you don't have to go through this process alone, and that we are here to be resources for you and to help you get to the next step that you need to be in. So take good care, and we'll see you next time. That's all I have for now. New episodes of the Probate Podcast will come out on Thursdays. I also have a free public support group called Houston Probate Support on Facebook. You don't have to live in the greater Houston area to be a member, but I'd love to have you join me there. I'd love to have you join me on any of these platforms, including this podcast, and I'll share the links of where you can find me in the show notes below. I'm looking forward to us connecting. See you next time, and remember, you matter.